Well, good evening, everyone. My name is Joel Crowder, and on behalf of the State Bar of Montana, I want to welcome you tonight to the Citizens Law School. And tonight's session is about a day in the life of a judge. And we have three wonderful district court judges here with us tonight who have agreed to participate and share some of their thoughts. I'm going to get right into doing a few introductions of our judges, and then I will turn it over to them. And I'm going to start with Judge Snipes-Ruiz. Judge Ruiz is Snipes-Ruiz is from the 12th Judicial District out of Havre. Her district covers Hill County, Choteau County, and Liberty counties, and she's been on the bench since 2019. She was born in Great Falls, graduated from Gonzaga University with her JD in 2011, and began her law career in private practice before becoming appointed to the Regional Deputy Public Defender from 2014 to 2018. She's also been an adjunct professor at the University of Montana, and she was appointed judge by Governor Bullock in 2019 to fill the unexpired term of Judge Bocher, who resigned in 2018. Judge Snipes-Ruiz and her husband have one daughter and a son that they welcomed in 2024. Judge Mike Menahan is out of the 1st Judicial District, Lewis and Clark County. And Judge Menahan graduated from the University of Montana with a degree in political science and a JD. And as an alumni of myself, go Grizz. He served as the Deputy Lewis and Clark County Attorney for 18 years and was elected to the Montana House of Representatives from 2009 to 2013, and then was elected to the bench in 2012. He and his wife Stacy have two children. Judge Jessica Fehr is out of the 13th Judicial District of Yellowstone County and has been on the bench since 2018. Judge Fehr grew up in Billings, Montana, and received her BA in political science in 2001 and Juris Doctorate in 2004 from the University of Montana as well. Judge Fehr worked as an associate at Moulton and Bellingham in Billings from 2004 to 2006, and then was an assistant U.S. attorney for the District of Montana from 2006 to 2013 before returning to Moulton Bellingham prior to her appointment to the bench in 2018 by Governor Bullock. And so thank you all for agreeing to participate tonight. And I guess however you want to proceed, I do have a few questions that we can get into, but I'll also be monitoring questions from the audience tonight. And I'll turn it over to maybe Judge Snipes-Ruiz to start things off.
Sure. If we're going to talk about kind of the theme tonight, which is a day in the life of a judge, I would tell you, as a general jurisdiction judge at the district court level, every day is different, but every day is the same, right? So as district court judges, we cover everything. We cover the criminal cases, we cover the civil cases, the involuntary commits, the youths in need of care. I personally preside over a treatment court, and I believe Judge Fehr does as well. We cover the probates, we cover the family law. So not every day is the same, certainly. We spend a lot of time in court. I personally am usually in court usually 3.5 to 4 days out of the 5 days of the week. If things are going smoothly, if things are not going so smoothly, it might be more than that. And all in all, I think it's a situation where, folks are coming. We're trying to get folks in as quick as statutorily allowed as far as trying to get the cases heard. It's a challenge every day, but it's also something that I've very much come to enjoy. So I think that's kind of a good place to start with, is kind of what we do every day. I'd turn it over to Judge Menahan if you'd like to take it from there.
I guess just to emphasize, Montana has, I think, 54 or maybe 56 district court judges, which cover the entire state. I can't remember how many cases that all of us preside over. I think a total it's around 200, 250,000 or so. So that includes criminal cases, which I think the public is aware, family law cases, civil litigation, and then, as Judge Snipes-Ruiz mentioned, involuntary commitments. So these are commitments for people who are suffering from a mental disorder and need commitment to the Montana State Hospital. Youth in needed care cases where parents are alleged to have been abusing or neglecting their children. We do adoptions. I think probably the only happy thing that we get to do as district court judges. And then, we wind up getting our names in the paper occasionally for some litigation, whether it's a criminal case or whether it's civil litigation. In Helena, we get a lot of challenges to legislation that winds up invoking rights guaranteed to Montana citizens under the Montana Constitution that sometimes gets us get our names in the paper. But about 99% of what we do only involves the parties who are in front of us. It doesn't get a lot of attention publicly, but it means it's a huge case, the most important case to the people who are appearing in front of us. That's all I have to add.
Judge Fehr, do you want to, I guess, share your thoughts?
Thanks, Joel. I think that Judge Snipes-Ruiz and Judge Menahan have really explained what we do as judges, whether we're in a smaller jurisdiction or in Billings, the largest jurisdiction. Uh, we all cover the same things. Something that Judge Snipes-Ruiz mentioned is a treatment court. And I think a lot of people don't understand what those are. We do have, I preside over two separate treatment courts here in Yellowstone County. Judge Snipes-Ruiz has one in her jurisdiction. The purpose of those courts is to offer individuals who find themselves entangled with the criminal justice system because of addiction. The two courts that I manage, one is a full diversion court, where if an individual finds themselves being charged with a first felony, again related to drug use. So that could be a criminal possession of dangerous drugs. It could be a theft because they were stealing something in order to buy drugs. It could be a DUI, it could be a criminal endangerment. We give these individuals the opportunity to have their charges completely dismissed. They contract with us to have 2 years in a treatment court where they're required to complete substance abuse treatment, mental health treatment. They're supposed to find a job, find housing stability. We do individual criminal thinking errors courses to try to teach them a better way to think, maybe a way that you make better decisions, and kind of provide overall wraparound services. If those folks are able to do that in the time period that they're in my court, then they never have a felony record and they're given the opportunity at a fresh start. We've created another track within that court where we focus on individuals who maybe had their first felony conviction and weren't able to manage it on their own, where they're about to be revoked or brought back into the system by a probation officer. Those folks are given another bite at the apple, where they remain on probation, but we give them again the wraparound services that can be provided to help them be sober and stable. The other court that I help manage is a family recovery court. So these are individuals that have had the state come in and remove their children for the safety of the children through the Department of Health and Human Services. We work with those parents, always focused on the best interest of the child. But in Montana, our Constitution explicitly guarantees parents the right to parent their child. It is a constitutional right in the state of Montana. And so we take that very seriously and protect that. And where possible, again, we help to stabilize families and reunite children with their parents. And where that's not a possibility, we seek to find stability for the children. So uh, probably my treatment courts are some of the most rewarding things that I do as a treatment court judge. Kind of gives you most of the time a little ray of hope in what otherwise can be kind of bleak cases. But I think it also should give hope to the rest of the community that there are things that we can do to save families and stabilize families and help people who have ended up on the wrong side of the law because of addiction. I don't think there's anybody in Montana that doesn't know someone or have a family member or a spouse or a relative who hasn't struggled with some level of addiction. And I think the sooner we recognize that, talk about it honestly and openly, and deal with it, the sooner we're going to be able to manage these issues as a community. I don't know if Judge Snipes-Ruiz, you had anything to add, as I know you also run a treatment court.
Sure. Ours runs a little bit different. We are a treatment court with two different tracks. We have a DUI track and we also have a drug court track. And so as an alternative sentence to 6 months in the Department of Corrections for the WATCH program, folks can plead on a DUI 4 to the treatment court instead of that. Ours runs, it's contracted for up to 2 years. Folks can get it done in 1 year. We're seeing an average of about 18 months, to be perfectly candid. That's usually kind of our sweet spot to get people the services that they need and the wraparound services. We're really lucky along the High Line to have the treatment court because there aren't as many services just in general for our folks for rehabilitation. And so we feel really lucky to be able to be involved with that.
Great. Judge Menahan, do you have anything you want to add to that?
No, I think if the participants have questions, maybe I'm
Yeah.
happy to answer questions.
Absolutely. So yes, if you do have a question, put it into the chat and I will help monitor that. While people are thinking about that, I do have an opening question that probably is the same for all of you, but may look a little bit different. But what does an average day as a judge look like for you? I think maybe a lot of people on here may just wonder, like, how much time is spent in court versus you're writing an opinion or doing other things. Yeah, if you want to take a swing
You
at
know,
that.
I can start.
Yeah.
I don't think necessarily a day in the life. I look at it as a week in the life because I have jury trials scheduled on most weeks. Although, I probably have 15 jury trials, I suppose, annually. But I have a lot of jury trials scheduled. They don't always go. When I don't have a jury trial, I have evidentiary hearings in different cases, family law matters in which people have disputes over their marital estate, their property, or their children. I have oral argument in a number of motions, evidentiary hearings on motions to suppress evidence in criminal cases, and a lot of different hearings. On Wednesday mornings, I have my criminal law in motion, and that generally takes anywhere from 2 hours or more. And that's when I have initial appearances, arraignments, change of pleas, bond hearings, sentencing hearings, and criminal cases. On Wednesday afternoon, I do my uncontested civil matters. That could be an uncontested dissolution, uncontested probate type cases. And then at 3 o'clock every Wednesday, I have my youth in need of care cases. The other days of the week are just filled up with various hearings. Fridays, I try to keep mostly clear so that I can work on orders in all the different motions that are filed. And one Friday a month, the first Friday a month, I go to Townsend because Broadwater County is part of our jurisdiction and I preside over cases there. So I look at my time in terms of a week. So whenever I'm not on the bench presiding over some case, I'm in my office trying to deal with the massive load of paperwork and motions that are filed by parties in which I have to issue an order. That's all.
Thank you. Anyone else want to add anything else to that?
Sure, Joel. I think another thing that the public sometimes doesn't realize that we do is we also do search warrants. Law enforcement does not have the right to search a private person or a private place without authorization. In order to do that, they have to obtain a search warrant from a judge. Um, this also applies to critical evidence in, say, a DUI, like your blood. In order to do that, they have to establish probable cause in a written affidavit or a telephonic affidavit to a district court judge or a misdemeanor judge if it's a misdemeanor charge. And so most of the law enforcement that I work with, thank goodness, which is Department of Criminal Investigation, Division of Criminal Investigations, DCI, which is kind of like the FBI for the state of Montana. They do statewide investigations as well as the local police in Billings and the local sheriffs in Billings use something called Secure Warrant, which is an online cloud-based portal to do search warrant applications. When I first started being a judge, I had little tiny humans in my house, and the police would call me at 2 and 3 in the morning to get a paper search warrant. And I was the creepy neighbor that would run across the street to my neighbor's driveway, and the police car would pull up and I would get in their car and I would read the affidavit and I would sign it. And then I'd get out of their car and I'd run back across the street to my own house, because if they woke up my golden doodle, they were going to wake up my kids and then we were going to have a problem. But now they just give me a call and I do it all on my phone. So it's much more convenient. Um, I'm again in a large jurisdiction. And so I bet I do between 20 and 30 search warrants a week, all hours. Sometimes they still are in paper and they'll come to my office or my house with those. But it's really things like a traffic stop happens, the officer can see in plain sight evidence of methamphetamine use, can see burnt tinfoil, can see a torch, maybe they see white residue, they see a baggie with white residue, and they'll establish probable cause in order to be able to get a search warrant. So once they have a search warrant, they can search the vehicle, they can search a home, they can search a package, and once that's all done, then they have to return it all to me. So then that's a next step where we have to do some more paperwork. So I think Judge Menahan is right. I have taken his lead. He suggested that when I first became a judge. I try to keep my Fridays open because I estimate for every 1 hour I'm on the bench in court, I develop an hour of paperwork minimum. So it's hard when you're on the bench 7 or 8 hours a day, knowing that now you have 7 or 8 hours of paperwork you have to do. You still have to find the time to do that. So some days are long, but it's a pretty cool job.
I would just add to that. I have a similar, situation as far as, the caseload, the things. I also try to keep my Fridays open as well, to get through stuff. Because I am a rural judge, and I preside over 3 counties, my schedule looks a little different because I have to make sure that I make it to all 3 of my counties. We have a general flow of things where I have designated days where I live in Havre. I'm based out of Havre, but there are specific days out of the month where I have to find time to drive to Fort Benton, and drive to Liberty County. And so we make all of that work. So a lot of the challenge for us is finding enough time to make sure logistically I can be where I need to be and have enough time to spend that time with litigants. Something that neither of the judges have mentioned is that, you have this beautiful schedule figured out, but then all of a sudden you end up with a youth that is in custody, where you have 24 hours to set a hearing. You have someone or an involuntary commit gets filed and those are emergent situations and you have to find a way to fit it in. Those kind of situations crop up all of the time. It almost seems to be a running joke in our house that heaven forbid I go, to Great Falls for a doctor's appointment. I guarantee I'm going to get an involuntary commit that day. That's just how it works. So it's not strange in our household with my family for me to be, well, mom's gotta do court, and then we'll go into, this appointment, or mom's got to do this. Well, I'll come meet you guys here in a couple of minutes. And it wouldn't be strange for that to happen in our house. But certainly it's something that we as judges have to deal with on a daily basis, because even if you have everything planned out, something is going to crop up that day.
Great, thank you. All right, we do have a few questions popping up here, so I'm going to go to our first question, asking if you can explain more about civil commitment proceedings and what kind of trends you are seeing in those types of cases. So, Judge, yeah, whoever
Yeah,
wants to go first.
I'll start if the other panelists don't mind. So when I went to work at the Lewis and Clark County Attorney's Office in the early 1990s, I was assigned handling the involuntary commitments to the Montana State Hospital as a deputy county attorney. So I continued to do that the entire time that I worked as a prosecutor. It's a civil process, but deputy county attorneys are responsible for it. And then I've been a judge for 13 years in Helena. You asked about what kind of trends you're seeing. In Lewis and Clark County, we've seen a drastic reduction in the number of involuntary commitment proceedings. In the height of some of the years where I was handling petitions, we filed as many as 200 petitions during the course of the year. The vast majority of those, or at least well over half, wound up being dismissed, and the person didn't wind up being committed, but they wound up being detained involuntarily, and usually for a few days before they stabilized, and then the petition was dismissed, and they got treatment in the community. Now, I think the trend that I'm seeing is that a lot of people are diverted before the county files a petition for seeking involuntary commitment. Nonetheless, the Montana State Hospital is at capacity. The hospital was built during the Roscoe administration in the 1990s. Originally, it was licensed, I think, for about 180 patients. It's well exceeded that capacity for years, and they've been under a lot of pressure by civil rights litigators and the federal government to reduce the size of the overall population at the state hospital. The big problem I think that all of us are seeing is that there are a great many people who suffer from mental illness who wind up committing crimes. And somebody raises the issue of whether or not the person is fit to proceed to trial, whether their mental illness prevents them somehow from understanding the nature of the proceedings against them. And so we have a huge backlog of inmates who are sitting in county jails waiting for an evaluation to occur at the forensic unit at the Montana State Hospital to determine whether or not they're fit. And if they're not fit, whether or not the court should order involuntary medication to make them fit prior to trial. So that's something that the legislature and the Gianforte administration have tried to address in recent years. I would say the problem isn't solved, but the administration is spending a lot of attention on that to try to address the problem and reduce the backlog of inmates who are sitting in county jails around the state waiting for an evaluation. That's all.
Great. Anyone else want to add anything?
Joel, I was just gonna say on the civil commitment side, so that's the civil proceedings that Judge Menahan was just talking about. It's a statutory test, so it's not how does this person make me feel? The question is whether or not the individual who's being evaluated is a danger to themselves or others. And under the subsection of whether they are danger to themselves is included not just kind of a traditional suicide analysis or suicidal ideation, but also are they unable to care for themselves in the community? So if we have individuals who a welfare check is done by local law enforcement and they are unable to manage their own funds, take care of their own activities of daily living, they're living in squalor, they're living somewhere without adequate heat or shelter, They are vulnerable to other individuals taking advantage of them physically, emotionally, mentally, or financially. Those are all things that can be presented to us. The way that it works is a person is taken to a local psychiatric facility. Again, in Billings, we have that. We have the Billings Clinic Psychiatric Unit. In a lot of smaller, more rural communities, they don't have that attached to their local hospital. So those folks are then either sent to a larger facility like Billings, like Missoula, like Helena, and held there. Sometimes they're held at a local hospital in those smaller jurisdictions. Some jurisdictions have facilities within their local jails where those individuals can be held. It just really is dependent. And then we have to have a very quick hearing to make sure that they are advised of all of their rights, that they have counsel appointed. So the Office of Public Defender is appointed to represent them. Then they have to be evaluated by a medical professional. The medical professional has to provide a written report. And then there's an evidentiary hearing that is scheduled. And at that time, they can ask questions of the medical provider, they can offer their own testimony, they can call their own witnesses, and then the judge has to determine whether or not the criteria is met and whether or not that person should be committed against their will to a state hospital, because that is the least restrictive option available to the court. So we follow the same process no matter what jurisdiction you're in, because again, it's all spelled out in statute what we have to do.
Great.
I would just add on to that with Judge Fehr's comments that regarding especially, because a lot of people are maybe wondering, if people are not adequately housed, those kinds of things. The reason that they are unable to care for themselves has to be a mental disorder. And that is the reason why they have to actually have a diagnosis. And that has to be diagnosed by a professional person to a reasonable degree of medical certainty. So two kind of factors there as far as things go. Also, again, when we're talking about challenges, in those proceedings, they can request a jury trial, and that jury trial has to happen within a week. And so we're looking at a situation where, you may have your week planned out just fine, and then you have to find a way to have a jury trial in that.
One interesting thing about involuntary commitments, the average length of stay for a person committed involuntarily to the Montana State Hospital is 30 days. And a huge number of people are released after a week, 10 days, sometimes less. Sometimes they're released within a couple of days. The only restriction on the director of the Department of Public Health and Human Services and the administrators at the state hospital is they have to give us notice when they release somebody. So there might be a misconception amongst the public that if somebody's committed to the state hospital, they're never released back into the community. But that's not true. There are some people who are essentially institutionalized, who've been there for a long period of time and are difficult to place in the community. But for the most part, the state hospital exists as a crisis stabilization center for people who can't be stabilized in their community in a less restrictive environment.
Great. Thanks for adding that. I appreciate that. We do have another question here, and it's kind of on the same topic of mental health. It says, it has been mentioned how difficult much of the cases presided over can be, and noted which kinds of cases are the feel-good ones. How do judges balance the work with their own mental health? Anyone who wants to take that one first?
Well, there's no balance, Joel. There just isn't. I mean, that's the thing, that the
Yeah.
fallacy, the work-life balance, it's a myth. I say that as a single mom of 3 kids, who works more than full time, but you do have to be aware of it. I think we have all gotten a lot more, not getting to, as my 70-year-old mother would say, woo woo. It's definitely more of we have to be aware of the trauma, not only that we see as judges that preside over sexual assaults, rapes, homicides, significant domestic violence cases, child abuse cases, this becomes a part of our lives. Um, we also have to realize our staff is exposed to that. My judicial assistant, my law clerk, they didn't sign up for what they're seeing. So I try to be very thoughtful and mindful of what everyone is seeing in my courtroom, and we talk a lot about it. And sometimes there's ice cream, sometimes there's carbohydrates that are brought to the office because sometimes sugar just makes you feel better. But I also think that you have to find your outlet. For me, it's a Peloton that exists in my basement. On good days, I ride it once. On bad days, I might ride it 2 or 3 times. I have a giant dumb golden doodle, Walter, who's sitting with me right now. Walter and I go on a lot of walks because you have to shake it off and you have to move forward and you can't take it home. That's the toughest thing. You cannot take this job home and burden your children with it or your spouses. So it's really important to make sure you process it in a healthy way. It's too easy, I think, in the legal profession and a lot of high stress, trauma filled professions to rely upon substances, whether that's alcohol or whatever it is. And so my go-to is a walk or a workout session on my Peloton or some sort of nonsense with my 3 sons. So I think you have to be very mindful of it. And I honestly appreciate that one of the citizen attendees today recognizes that. So thank you. That means a lot. I think we all love our jobs, but there can be really tough days sometimes.
Anyone else want to add?
I don't think I could have said that any better than Judge Fehr.
Mm. All right. Yeah, that was well said. Another question here. What is the hardest thing you found about being a judge?
You know, I had been, I think all of us, but my experience was I was in trial or I was in court on a pretty regular basis. The one thing that surprised me when I took the bench is that when I walked out to the bench first time and I looked out into the sea of faces in the courtroom, it made me realize I'm the only person looking from the bench in that direction. Everybody else in the courtroom is focused on the judge. Their attention is directed towards the judge because they're talking to the judge or they're presenting evidence to the judge. And so it's a little bit of a change in mindset because you're the only one that's making that decision. We're district court judges. We're not appellate court judges. So we're all of our decisions can be appealed to the Montana Supreme Court. So we work as a single entity. I think all of us worked with colleagues before we took the bench, but when we became judges, really, it's nice that you get to make the decisions, but on the other hand, the monkey is on your shoulder and you're the one making the decisions, and they're not always easy decisions. And then again, I think just sitting on the bench, you realize you're the one doing it. There's nobody else behind you, no one else besides you. You don't have the camaraderie that you had, when you worked as an assistant U.S. attorney or you worked as a lawyer in a law firm or as a prosecutor like I did. So that's really a big change that I noticed, and I'm still getting used to it. Yeah.
I would 100% agree with what Judge Menahan said. Prior to coming to the bench, I was the regional for the Office of the State Public Defender. I spent a ton of time in court. And there's certainly being in the courtroom is a space where I'm extremely comfortable. And that's something I did not expect getting on the bench was that the amount of pressure that I was going to feel, even though I already had a high pressure job shift. And again, when we're talking about that balance, the level of isolation when you are the one and you are by yourself and you can't really talk to anybody about anything. Not really your spouse, not really your spouse, at least in a specific sense. Hopefully you've got a good law clerk, but that's not even guaranteed. And so, again, finding those outlets. It's not a secret that I ice curl in the winter. I golf in the summer. Try to get out and enjoy my dogs and my kids and my husband when my husband also is gone 200 days a year. He's a railroad worker for BNSF. And so it's one of those things where you try to find the way to make it all come together.
Judge Fehr, did you want to add anything to that?
No, I think it was well said by both judges.
Okay. All right, we have another question. Says, what moved each of you to decide in your legal career to have the honor of being a judge in your jurisdiction? So I guess just why did you decide to make the leap, maybe from being an advocate and to becoming a judge?
Well, I don't.
Okay, so
I was gonna. Mike, are you gonna go first?
you go first,
Okay.
please.
We probably all have the same theme. I'm gonna bet. The nice part about being one of 56 is that we get to know each other. Thank goodness. Because those are the people we rely on to talk to. So I blame my parents and I blame Law and Order. I think I've seen every episode back to the Lenny Briscoe days. If you're a Law and Order person, you know what I'm saying. I came out of law school. I wanted to be a litigator. I was at a private law firm. I think I had one trial in 2.5 years, and I was so bored and I couldn't do it. So then I had the opportunity to go to the US Attorney's Office, tried all kinds of cases, doing all kinds of things in all kinds of great courtrooms and with all kinds of amazing judges. And after I'd had 2 babies doing that and had been really, really busy, I decided I needed to not try a case every month and maybe I needed to slow down a little. And so I went back to private practice and I was a partner in a law firm and I did medical malpractice defense. And I loved it. It was fantastic. It was interesting work. I really liked my colleagues. It was fantastic. But after 5 years of doing that, I got really tired of having my life revolve around every 6 minutes because private lawyers bill in 6-minute increments. And so you would be standing in the line at the movie with your children and you'd stand there for 18 minutes and you'd go, well, that's a 0.3 I'm never going to get back. And I also really desperately missed being able to say to my sons, this is what mommy does and this is what I'm doing to make the community better. So I had joined all kinds of boards and I was on all kinds of community groups trying to kind of fill what I now recognize was a void to try to give back to my community. And the opportunity came open and I thought, well, here we go. What do I have to lose? The worst thing they can do is say no. And so I applied to be a judge because I felt like it was a way for me to still be in the courtroom, still be watching litigation or participating in litigation, but also giving back to my community. So that is why I blame my parents and Law and Order on why I decided that this was the career move. And I don't regret it, not for 1 minute. It's exhausting and it takes a little part of your soul, but it's the most fulfilling thing that I have done in my legal career. And I've been doing this for 21 years. So it's a blessing to have this job.
Great, thank you. Anyone else want to weigh in on that question?
So I, I didn't have any lawyers in the family. I grew up in Anaconda. My dad was a teacher, and most of my family members worked for the Anaconda company. I have an older brother who was in the operators union and worked at the Rosebud mine for 30 some years in Colstrip. I went to law school. I was a seasonal forest firefighter for a long time. I went to the University of Montana. Decided to go to law school because I figured that I could earn a good living and stay in Western Montana and raise a family kind of thing. But I didn't have a very good idea what lawyers did. So I kind of fell into being a prosecutor and I really liked it. I like being a litigator. I like going to court. I like the fact that I didn't have clients in the traditional sense, that I was essentially trying to achieve justice. I wound up kind of specializing in some things. I did a lot of involuntary commitments. I prosecuted cases where people had a mental disease or disorder. I wound up prosecuting a lot of domestic violence cases. I prosecuted pretty much all the felony domestic violence cases in Helena for 15 years and served on the board of directors for the Friendship Center, our local domestic violence shelter. So I served a couple terms in the legislature, which I didn't find very fulfilling. Um, I like being in court. I like the structure that the court entails. I like how facts are facts in court and you don't get to pick and choose facts to support whatever policy you're trying to, you know, get passed by the legislature. I I like being in court. So in 2012, Judge Dorothy McCarter, wasn't running for reelection, so I filed and ran for her seat. So I was elected in 2012. Sworn in on January 1st, 2000, or January 6th, whatever date it was. I joke, I was sworn in on January 2013 and sworn out every day since. But then I got reelected in 2018 and reelected in 2024. Montana District Court judges are elected. We're nonpartisan. We serve 6-year terms. I just like the, and I didn't, when I went to law school, being a prosecutor was not on my radar. I didn't even realize that that was something that I would want to do, but I wound up doing it and enjoying it greatly. And and being a judge wasn't really on my radar either, but the opportunity came up and I thought that I would enjoy doing the work and it would be challenging. And that has turned out to be true.
Thank you.
I suppose I'm kind of, when we're all telling our stories, they are kind of similar, aren't they? So my undergraduate degree from Montana State University is sociology with an emphasis in justice studies and political science. When you're looking at that, you go, well, you can either go and get your master's in social work or you can go to law school. Those are kind of what you do with those kind of degrees. And I figured if I became an attorney, I could make a bigger difference kind of doing the same thing and people listen to the lawyers. They tend to. I didn't think I was going to be a public defender. That was not the plan. Coming, out of law school, I had worked at the Cascade County prosecutor's office during internships. I worked at the U.S. Attorney's office during internships. I worked with some victims groups in Spokane when I was in law school. And so I was thinking that, but I took a private practice job, ultimately got conned into doing some public defender contract work. And then I realized, oh, this is where you can make the difference. It's actually in doing the public defender work. You can get people hooked in with services. You can do things to help people. When the seat came open in Havre, and I think this is pretty reflective across the Highline and rural Montana, there just aren't a lot of attorneys in my area. They're just not a lot. There's a lot that are very close to retirement age, and there's not a lot of young attorneys moving to the Highline, moving to Eastern Montana. I know there's shortages too in Billings and Helena too, but in those rural areas in the eastern part of the state, it's pretty significant. And so it was not a convenient time for me to get on the bench. I was at home. My daughter had been born in August, and I was still on maternity leave, and I started getting the phone calls from local attorneys and, to be candid, the local justice of the peace saying, hey, you can do this. This would be a fantastic thing for you to do. The other candidates that were going through the judicial nomination process certainly were very well qualified. What I knew I could do was I had been at the regional public defender's office, so I was running about 1,500 cases a year through 6 counties. And so I knew it could move volume. And I was like, I know how to organize, I know how to move volume, I know how to do those kinds of things. Um, and make it all work. And so it was a situation where my community ultimately needed me to step up and to do that, even if it wasn't a convenient time for me to do it. And I loved being a trial attorney, but I also agree with the comments that Judge Fehr had to say that I don't regret it, not 1 ounce. I love being a judge. Of course, you wish there weren't as many hard days, but it's truly an honor to be on the bench.
Great, thank you. Okay, another question we have is I guess it says, what preparation would you like to see before a pro se litigant goes to court, goes to a hearing? I don't know how often you see, pro se litigants, and just maybe what they can do to make the process a little easier or straightforward. Anyone that wants to take that?
Sure.
What-
So we see a great deal of pro se litigants a lot. We see them primarily in family law cases, but we see them in civil litigation as well. I think one thing to know as a pro se litigant that you have to follow the same rules as attorneys. We can't make exceptions. Attorneys are required to follow rules of civil procedure, rules of evidence, and other procedural rules that dictate how cases are brought, what evidence can be presented in court. I think a great many of people believe that if they have a problem, they can show up to court and the judge has the power to fix it. And the judges don't have the power to fix their problems. We preside over cases in what has been crafted over centuries, an adversarial system of justice. Judges are neutral. We're there to make decisions based upon the law and the evidence that's presented to us. Pro se litigants often have a very unrealistic idea of the courts and their view of the role as a judge. They see themselves as aggrieved in some fashion, and if they can only explain things to the judge is going to, issue some order that's going to take care of their problem. But in doing so, they're not able to marshal their evidence before us in a manner that is required, by calling witnesses who can establish the facts that they want us to consider. They don't show up with documents to establish the facts that they want us to make, and they don't understand the law. So we do have some pro se litigants who are pretty well informed. In family law cases, we give them a great deal of opportunity, leverage, latitude in order to present their cases so that we can make a decision related to it's mostly their children, but sometimes it's their property. And we give them a lot of latitude so that we can make an informed decision regarding what is a parenting plan that's in the best interest of the children, and to what degree do the parties get to share in the assets that they acquired during their marriage. But we see a lot of people that file lawsuits that simply aren't prepared to prepared to follow the rules well enough to have their case resolved in court by a jury, if that's what they intend to do so. We get a lot of cases where somebody files a pro se complaint and the other side's represented by an attorney and files a motion to dismiss or motion for summary judgment, because there really isn't much of a merit to the plaintiff's case. We spend an inordinate amount of time dealing with unschooled pro se litigants.
So I
Great.
think I would, sorry, Joel. I
No,
think
go
I
ahead.
would recommend too. There are resources that are available to pro se litigants, and so I think part of it is making sure that those pro se litigants are savvy to them before they come before a judge. The Montana Supreme Court's website has some amazing forms, and it's not just the forms; it's actually a packet. So if we're talking domestic relations, so we're talking dissolution of marriage, parenting plans.
Probate.
Um, there are some great packets there where they actually walk you through the forms and help you and can walk you through the next step will be a hearing. And this is what you can expect. Montana Legal Services has some amazing resources where you can actually request a consult with a pro bono attorney who will assist you in evaluating maybe where you are, what you should do next. The other thing too is we've instituted a new plan or a new policy in district courts. I'm sure I'm going to screw up the name. It's called IDIRT, Informal Domestic Relations Trials. So what that means is, especially in a pro se litigant case, the judge can kind of step in and assist by asking questions of the parties so that the two litigants aren't asking questions of each other, because there's nothing that I think is more ripe for law enforcement being called to your courtroom than when you have two pro se litigants where there's heat between the two of them. You know, there was passionate love at some point and now there's passionate hate, and they're in the courtroom and there's no lawyers and they're fighting over the TV trays that Grandma Susan gave them, and they're not backing down. When you can institute this informal process, the judge can kind of take the emotion out of it and proceed. So in Yellowstone County, in all of our scheduling orders, parties are given notice that that's how we're going to proceed, and they have to opt out of it. So I think that's an important thing for pro se litigants to know. I also think it's important for people to understand I can't have you handing me your phone. So if there's text messages that you want me to see, if there's an email you want me to see, if you have photographs, you got to get them off the phone, because there's nothing more fun for a judge than when the litigant is walking up to your bench and handing you, their cell phone, and they want you to look at this one picture, but don't look at anything else. And then you got to say, but you have to take the phone over to the other side because they have to see what you're going to show me first. And so then again, we're encouraging contact between the two people. So for pro se litigants, use the resources, see if your jurisdiction follows the informal domestic relations trial process. And if you want me to see something as a judge, show up with a paper copy, one for me and one for the other side. Because it gets real messy when I'm handing everyone's phones around, and it can create some ugly situations.
I just add along those same lines that I believe in conjunction with the state bar, there's also free mediation that's available for folks that are indigent. And so we're often making referrals for that. And also with the IDRT trials, I'll just tell you, when we're talking about, so many cases to do in this much amount of time, if it's an IDRT trial, I can usually get it on the calendar a lot sooner than I can for a half day or a full day trial. And so those IDRT folks actually end up with a priority because I can squeeze them in a 2-hour session as opposed to, setting aside an entire docketed day. And so it creates an ability to get that justice to folks faster as well.
And just, so I think at some point, some of the attorneys might talk to you about rules of evidence. So we judges are taught as to what kind of evidence can be admissible during the course of a trial. In an informal domestic relations trial, the rules of evidence don't apply, or they're very much relaxed. And judges wind up taking a more active role in those proceedings rather than acting as this neutral umpire or referee. We take an active role in asking a lot of questions of the parties in order essentially to determine what's in the best interest of your child. what parenting plan is going to work for you, what's in the best interest of your kids. So that frees up judges to be able to take a more active role, something that historically judges weren't trained to do. I think that all of us, after having a lot of courtroom experience, we're pretty good at asking questions. So, so we can ask a lot of questions during those hearings in order to develop a parenting plan or a property settlement order.
Okay, another question here. We're hearing a lot about AI. Are you starting to see its influence in your courts and how?
I would just say it's hard to say. Not very much, really. Occasionally, I get somebody. They're almost always a pro se litigant who file a brief, and they've used AI in order to write the brief, and then AI makes up case law to support their position. So you wind up looking at the cases that they cited in their brief and realize that it's all made up. That's not very, very helpful to the court.
Along those same lines, is what Judge Menahan just said, we've been hearing about the AI, I think, just like everybody else, and it's coming, it's coming, it's coming, it's here. And so I have changed the way that I work with my law clerk. A law clerk is usually a young attorney or a new attorney, maybe not young in age, young in spirit. But they are a first or second year graduate from law school. A lot of times it is a first year job. We Some jurisdictions do have long-term law clerks where they are more seasoned attorneys. But their job is to help us. So they help us research, they help us write, they help us manage the courtroom, keep things organized. It's kind of our right hand. And my law clerk now, the first step, if she reads a case in a brief that she thinks is interesting or really on point, our very first step is we double check the site. Because, like Judge Menahan said, what AI will do is it will generate a case site that may be similar to an actual site, but truly isn't a legal site. So it's for an untrained lawyer, it looks good, but it's fake law. I think a lot of jurisdictions are also developing. I know Flathead County has already done it. I don't know if Lewis and Clark has. We're working on it in Yellowstone County, a specific policy on AI where we will be asking attorneys to disclose if they are actively using AI in the drafting. AI can be used to draft briefs, it can be used to edit briefs, it can be used for legal research. And so there's some push in some jurisdictions to require lawyers to disclose if they have used AI in the briefing process. So I think it's really evolving. I think things will change a lot for us in the next 2 to 5 years. But the funniest thing is I saw it, my sister, because of course, her sister's a lawyer, me. So she is by extension a lawyer, is I think how she thinks about it. So she called me the other day and she said, look, this insurance company is giving us a hard time. Here's what I want to send them. She sent me what she wanted to send them. And I said, where did you get this? She said, well, I put it into Chat GPT. And I said, okay. I said, well, first of all, none of the citations are correct. You're not citing to any actual code that actually exists anywhere in the law. And the cases they've cited to aren't real cases. And so she was quite disappointed and said, well, how much would it take for a real lawyer to draft the same thing with real legal citations? And I said, you can't afford it. So, I mean, I think it's popping up in different places. So we all have to be mindful of it, that it is everywhere.
I would just add to that, if you're going to attempt to be using AI in some fashion in the courtroom, you really need to be letting the judge know in advance. I had this crop up this last week, and I honestly wasn't expecting it. One of the litigants was trying to use a note-taking type app, and I think there's actually one ironically on this as we speak, and adding it as one of the Zoom participants and was trying to do that. And I said, and no one would fess up to it. I don't know who did it. I said, who did someone add an AI, note-taking thing to our Zoom meeting? And no one says anything. And I said, well, I don't know who did it, but I'm gonna kick them out. It's not gonna be on our Zoom. And so no one admitted to it. But it's one of those things where if you're going to do that and leave the judge flat-footed, it's probably going to be a solid no. But had that attorney maybe talked to me ahead of time about why, that should have happened or could have happened or how that could have happened, perhaps it might have been a different answer.
Great. Okay, well, I think that brings us to the conclusion of our program tonight. I want to thank all of the panelists for those great answers and just, yeah, helping everyone kind of get a better idea of what a day in the life of a judge looks like. Next week, we'll be continuing with the Citizens Law School, and it will be Hertha Lund presenting on Montana property law, easements, and HOAs. So that will be next Wednesday night. And so I just want to thank everyone, the participants who joined us tonight, and our panelists. So thank you for everything, everybody. Have a good
Thank you.